Hi, my name is Crystal Reimler, and today I will be doing an informational presentation on gay marriage in the United States of America. Currently, there are 1,138 rights denied to homosexual couples that are guaranteed to heterosexual couples simply based on the fact that they can get married. Some examples of rights given by the process of marriage are right to change their last name at the time of marriage, tax-free transfer of property between spouses, joint tax filing, and the right to inherit property. While marriage in another state allows you to have many of these rights, living in a gay marriage ban state removes some of them. If my partner were to retire under the state retirement fund that she is currently under and passed away, I would not be entitled to it. Anything left in her name would require me to pay taxes in order to receive it, unless we went to an attorney and prepared for the situation. There are a few rights that should be guaranteed by the Constitution. According to the Full Faith and Credit Clause, which states the full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. If we were to go get married in Iowa and come back to Oklahoma, we should still be married. As it stands, because of the marriage ban, we will not be. An example of this is a couple from South Dakota. Amy and Ashley Stabe were legally married in Iowa. When they returned to their home state of South Dakota, they were denied licenses with their married names due to the state's ban on gay marriage. According to the Full Faith and Credit Clause, their marriage in Iowa should be recognized, and receiving licenses with their married names should have been allowed. Also in the Constitution is the Equal Protection Clause, which states, "No state shall make or enforce any law that shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protections of laws." According to this, you shouldn't have to pay estate taxes in a homosexual relationship if you're married. As it stands, nationally and federally, same-sex marriage is now recognized, but on a state basis we are not. An example of this is the couple Edith Windsor and Thea Spire. They were together for 40 years by the time Thea passed away. Edith fought against a $363,000 estate tax to keep the money they had shared their lives together in. She eventually won, which is not the case for many homosexual couples around the country. A lack of marriage recognition causes many issues within a same-sex relationship. Estate taxes, inheritance taxes, and medical issues affect the surviving partner in a way that few heterosexual couples have to deal with. There's a documentary called Bridegroom, and in it, one of the men in a homosexual relationship passed away. His family denied his partner the right to even go to his funeral. No medical arrangements was he allowed to participate in. He wasn't even allowed to even go into the hospital room during his last moments, but the nurses allowed him in against family rulings. So there are so many things that heterosexual couples take for granted. And the reality is homosexual couples, they don't get to partake in this. As tax-paying citizens, they need to be allowed under the Equal Protection Clause and the Full Faith and Credit Clause to enjoy these rights that other couples do. So, that's just a little bit of information, and I hope you take it into consideration, and it has opened your mind a little bit on the process. Thank you so much for listening, and have a wonderful day.